justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down may I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
All righty then. Hey, thanks for. I'm like an Easter egg hunt here. You got to find out what we're doing and when. Went a little long on the regular show, so I'm sorry to get into the members thing just a touch late. What we're going to try and do going forward, and I think it's a hell of a good idea, just because it's mine. We always do a couple of things on the weekend. Kind of we call them snacks, and I think what we're going to do is basically give our members the opportunity to partake in the snacks when we're recording them, and then we'll put them out for the more broad public a few days later. So they'll be live like this, so there'll be some interaction if you care to interact. So this is kind of the first version. This is the first version of that. So I appreciate you joining. And look at that, brand new member, Pugnacious Paralegal. That's a lot of popping P's there. Thank you for becoming a new member. We appreciate it. So what we're going to do tonight, because I've been dying to share this Cosgrove nightmare with you, let's do just a little bit of foundation here. The mega motion. Remember the motion to dismiss? It feels like we've been talking about it forever because it was filed so long ago by Mr. Betterow, that is, on behalf of Aidan Kearney, and it relates to the witness intimidation cases that remain against him. And I was just talking about the potential for witness intimidation when you're in Massachusetts. I'm very conscious of it because I think they would do it just because. If they think you're a pain in the ass and you just have a cordial conversation with a witness, that's not against the law. Anyway, so these cases are still pending against Aidan Kearney. I think it's something like 100 years possible in jail. Never happened, but it's kind of scary to have that hanging over your head. So they bring this big motion. We know all of the details of what has happened in the background with regard to those that may have sandbagged Aidan Kearney so that he A, was first accused of witness intimidation, and then B, violated and spent 60 days in jail. So this has all led to, this is 2 years in the making, and now this motion to dismiss has been hanging for a while. Most recently, what happens is there's a deadline for Cosgrove, the special prosecutor, to respond to the motion brought by the Kearney team. And that deadline for his opposition comes and goes. And people are seriously thinking, well, he's not going to just blow off that deadline. Normally, if he's sort of a solo practitioner, from what I understand, and you get swamped with things, you just reach out to the other side first and say, look, here's what's happening. I got this trial coming up. I got this. Can I get an extra week? More often than not, unless opposing counsel just hates your guts, you're going to get that week. And if not, then maybe you go to the court and say, here's the deal. And the court will give you that time. But to do nothing for 8 days and then just file your opposition with a note to the court saying, hey, I was busy, couldn't get to it. It's probably, just can I just have some extra time now? To file that at the same time as you're filing your late papers is unreasonable. It's outrageous. It's unprofessional. It's unethical. And probably he's going to get away with it because we know the courts in Norfolk County have their own set of rules, and they basically they aren't rules. They're just, some people have said they're suggestions. I'm not even sure they're suggestions. It's like they're notes. It's like they're on the back of a milk carton somewhere. Nobody's going to follow them. Nobody seems to give a rip. So we'll see tomorrow. And that's why I want to talk about this tonight. We'll see tomorrow whether the new judge, and I'm sure I'm mispronouncing his name. Tomorrow I'm going to be listening very carefully. Belezos. Judge Belezos is now the man, and he has said, I don't have time to get through all of this stuff. So the hearing on merits, not going to happen tomorrow. It's not going to happen. So we're going to have, it's going to be sort of a mishmash of him getting used to the case, whatever information he needs, and then maybe a scheduling of the motion to dismiss. Hey, thank you, Bama Rose. Appreciate that. Appreciate your membership. That was a lovely picture there. So let's get into this thing. It's beefy, and I'm going to do it not necessarily as quickly as possible, but as efficiently as possible. And here, I know, I think Brother Counsel went through this once, but I'm sorry, I got to go through it myself. I just got to. Let me see if I can make that as big as possible. Sometimes, see how this has my name by each of the pages? I guess that just because I looked at it. I've been outed, I've looked at it, and I did some decent highlighting, I like to think. So anyway, and he's already acknowledging, and I asked for, by the way, I asked to be pool camera for this hearing. Not a word back from anybody. Nothing. Not even thanks, but no thanks. The defendant has filed a group of documents supporting an unfiled motion or motions, most notably what is effectively a motion for reconsideration. Remember, there was a motion earlier to dismiss. They hang their hat on that big time, suggesting we already had this, Judge. We already had a motion to dismiss. It was denied. You can bring a motion to dismiss anytime you have new information that justifies, in your position, the motion to dismiss. And that's what they've done here. They got all of this extra information that came along after the fact about what the grand jury was given and how it was twisted and edited, if not by Tully, the MSP, Massachusetts State Police, by what's her name? I get Aidan Kearney's nicknames stuck in my head, and I can't remember their real names. It's horrible. K. Peter, thank you. Yes. Anyway. Memorandum of law in support of the motion to dismiss the indictments. That was the shorter version. Functionally, it's difficult to distinguish the Betterow affidavit from the memorandum of law, although it also serves the function of informing the court of what unfiled motion it is supporting. What? Anyway, is this the first of the word? No, he hasn't gotten into these words yet, the weird words he starts to use. The Betterow affidavit first lurches into a section entitled Background, which is essentially a hagiographic portrait, of the defendant as a crusading, heroic journalist, fearlessly pursuing the truth, exposing the falsehoods of the Commonwealth's witnesses in the Karen Read case, laying bare the corruption of local and state police, and something resisting the attempts of the forces of evil, aka the Norfolk County District Attorney's Office. Well, at least that's self-awareness, to deter him in his courageous and never-ending battle for truth, justice. I was going to say and the American way, but he finishes with and the First Amendment. Okay, so let's back up here. Hagiographic. I've got to go into my dictionary, the special Buchanan edition. That let me turn that to the page here. I've marked hagiographic, overly flattering, portraying someone as perfect or much better than they are. Okay, so burn. Okay, so I don't mind a little bit of smartassery, but come on. In reading Betterow's encomiums, hold the phone. Gotta go back to the dictionary. Encomiums, a speech or piece of writing that praises someone. So, obviously, he's talking about Betterow's affidavit praising Saint Kearney, which I think Aidan picked up and now has added that to his litany of names that he appreciates. I'm not even going to go into the Oscar Wilde reference. It's ridiculous. The Commonwealth has had occasion to respond to such drivel in the past, and with some reluctance now does so again. And a lot of this response, that's what I say. First thought I had was, this guy did not write this. I'm sorry. I just don't see it. Chat GDP. I don't know. This is almost too much for Chat GDP. Or is that the right chat? There's a few chats out there, Sheila. So I don't know. But it tries way too hard, really, to be a distraction, I think. I agree with you, Sherry. I don't think he wrote this. It's almost like, don't worry about the facts and the underlying nature of what's going on here. Look at my crazy linguistics that I'm throwing at you. And never once in these 26 pages does Cosgrove, or whomever wrote this, say, about the 8 days I was late. Sorry, I meant to do this. Nothing. No acknowledgement of it. Nothing. Arguably, they've waived the right to file this. And the court, if it had any balls, would say that and move on from there. And I can't wait to see if that happens, although I fully expect I will be sorely disappointed. Okay, so let's see, where's my footnote? Make sure we reference my footnote. Is that footnote? So what they've done here is they basically taken the response from the previous motion and they just cut and pasted it. So I'm not going to bore everybody going into that. I'm going to stick with the new meat. The reference to the footnote here is the indictments against Kearney at issue in the defendant's original motion largely, perhaps entirely, grew out of his activities connected with the Karen Read case and its witnesses. A subsequent set of indictments against Mr. Kearney named a former paramour turned informant for the Commonwealth, Lindsay Gaetani, as an alleged victim. Those indictments have since been dismissed. Yeah. Why is that? Well, because you, Cosgrove, can't be the prosecutor and a witness in the underlying case that's being brought. And you guys in the Norfolk County DA's office are so inept, you have nobody else that isn't or shouldn't be conflicted out. That's the truth. So that's why that ended. So you can try and flavor it any way you want, dude, but we know what happened. White Diamonds 480, thank you. Appreciate the YouTube membershipdom. I always try to read the logo or the icon or the avatar that you got there. Okay, I can't see it. Thank you for your support. This live is commercial-free, early access before posting. Look at that. Guess who did that? Missy, she is on this. She is all over this. Okay, so now we have, again, regurgitation of what we saw in their first response to the original motion, blah, blah, blah. And then blank page. This is not redaction. This is just whoever loaded this up had a blank page in there, and it just scanned a blank page. So, and then again, blah, 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 same thing we've heard before. Let's get into the argument. Having previously brought and fully litigated a McCarthy-Odell motion, referencing the prior motion to dismiss, the defendant has no right to bring a renewed attack on grand jury proceedings already upheld by this court. Arguments he previously raised have been considered and decided and are settled. Arguments that he failed to raise but could have are waived. If anybody is an expert on waiving, it should be Cosgrove. So let's get into some of these details here. Some of them I think were far more important, and I'm just going to jump right into them. On May 19, 2025, having the benefit of both parties' memoranda, copies of the grand jury minutes, and copies of the online experts played for the grand jury by the Commonwealth, the court, that is, Doolin, issued a comprehensive decision allowing the motion in part, dismissing 6 indictments as presenting insufficient evidence, primarily those that named Trupas as victims, but otherwise denying it. Neither party moved for reconsideration. Neither party, see, I did a neither and a neither. We had this conversation with Ms. Demeanor the other night. Is it neither or neither? I waffle. Neither party moved for reconsideration. Neither party sought interlocutory appeal. Now the defendant wants to do it all over again. Again, if you have new evidence, you have the right to bring this motion as often as you want. You can't get abusive about it. You got to be realistic. But that is not inappropriate. And when you're the guy that is late to the party, as Cosgrove is, and when you're the guy that's defending the shenanigans that took place at the grand jury, you just want to say, shut the fuck up and, take your medicine, dude. To be sure, a judge may permit a motion that has been heard and denied to be renewed when substantial justice requires. I don't think Cosgrove knows a bit about what that really is. Motion for reconsideration shall be based on duly discovered evidence that could not be discovered through the exercise of due diligence before the original motion was filed. Well, we're talking primarily about the doctored Aidan Kearney Turtle Boy show titles and substance. Remember, they just changed the titles of the shows and then they put them in the folder called Intent, and their goal was to convince the grand jury that, in fact, Aidan Kearney intended to intimidate these people, and here's how he did it. And the titles supported that conclusion. Talk about confirmation bias. To do that for the grand jury, it doesn't get more inappropriate than that. For his present motion for reconsideration, he now claims that the prosecutor and Detective Tully deceived the grand jury by grouping videos the Commonwealth offered as evidence of intent on a folder on the thumb drive exhibit labeled as Intent, showing edited clips that allegedly deprived the grand jury of viewing Kearney's actual full episodes, many well over 2 hours long, at least. Have you watched in a while? And 3, assigning titles to the edited clips that did not match the titles Kearney assigned the full episode. That is absolutely right. That's the thrust of this problem. And the overlap between whether or not this person is an agent for the government, or was it Tully that was doing all of this? And they talk about it in this motion. We'll get to it at bits and pieces. But to me, it's irrelevant whether it was Tully that came up with the editing and presented that to the grand jury, or it was K. Peter that came up with it, gave it to Tully, and then it went to the grand jury. It's a distinction without a difference. The grand jury was misled. Counsel's use of the term edited to describe the clips is artful and is falsely implying that the contents were somehow modified or distorted. Were that so, one might expect the 88-page affidavit, that was with the original filing, to offer examples of the edits, but there are none. Any idea why there are none? And that is because the edits consist entirely of exact clips of relevant content broadcast by Kearney. The only editing is selection. The appropriate course, according to counsel, would have been to show the entire episode of each show, or by Mr. Kearney's count, over 50 hours of content. First of all, over is the wrong use of the word there. Over is only to be used when you're talking about height. It should say more than 50 hours of content. But I digress. Pre-sending, is that what that says? Pre-sending, from any question, that's not in my Buchanan Edition dictionary, from any question as to whether subjecting the grand jury to such an extended dose of Kearney video would have violated the constitutional prohibition against cruel and unusual punishment, such a course would have inserted confusing and irrelevant material, and doubtless would have generated additional defense arguments that Kearney was prejudiced because the Commonwealth presented evidence of other conduct for which it did not specifically request indictments. So here's their position. We're giving you this little snippet. Here's the whole show. We can't do that. Well, why not give them 2 or 3 minutes before or after the content you think is the appropriate content for intimidation? You don't have to go all or almost nothing. There are midpoints within those 2-hour shows that would be reasonable. They could be, if you cared to show up, Cosgrove, they could be negotiated with the parties. But sometimes he doesn't do the right thing. Okay. Of course, the standards of a grand jury presentation are less exacting than a trial. A grand jury is not bound by the rules of evidence that hold a trial. Yes, that's true. But that doesn't mean you should mislead them. The grand jury hardly could have been misled, he says, by the titles Lieutenant Tully used to identify the excerpts he played for them. And then he shows some of the specific titles here. Trying to destroy Colin Albert's life. Well, that sounds like intent to intimidate somebody. Life as normal is over. What they did was they took some of the phrasing from Aidan Kearney's show, where he might have thrown out that line in the midst of some other tirade, and then they said, oh, that's the title. Now, and they're suggesting, well, what's the difference then? He said it at some point in his show. The difference is your goal has been, when going to the grand jury, is to group all of these things into, one big, one snowflake means nothing. A snowball, can knock you out. So they're putting all these little flakes into building a snowball, as that analogy continues, and they're using that to get the grand jury's attention and knock out Aidan Kearney, so to speak. Thank you, JD Kicks. JD Kicks, YouTube member. Appreciate that. Oh, let's see. Let me get this in here. Hey, it's me, 405 shares. Sometimes I'm just grabbing stuff. So if you put something in the chat and it pops up, sorry if you're trying to hide something. Feltwill calling out a former judge of unethical behavior. I think he probably is, but can't prove it. Yeah, I mean, and I don't even know because I dipped into your conversation here, Sherry. I apologize. But I think that could apply to many judges in Norfolk County. And why is it we're so surprised when somebody acts appropriately from the bench? As I think universally, everybody seems to like Judge Diane Frederi. So it can happen, even in Norfolk County. Footnote-ish time. Let's see, let me back up to the trigger for the footnote. Here we go. Referencing again the motion to dismiss. In trying to destroy Collins' life, Kearney begins by musing about whether Collins' aunt, Jill Daniels, we know her from that video, whose photograph he displays, has a crush on him, a proposition he modestly thought at first to be ridiculous. After asking his viewers to weigh in on this important topic, he opines that it's wild because I'm like trying to put her like godson nephew in jail and like kind of like destroy their life. But she also likes me. Like, what? Two comments. Daniels is not a witness in the Reed case, but as a relative of a witness, Kearney considers her fair game for humiliation. Boo freaking who? I mean, these people are so soft. It's frightening. Second, Kearney explicitly states the goal of his behavior with respect to Colin, destroy his life. So that's where they're incorporating that, making that fair game for the caption of something the grand jury saw. I had another comment here. I play no favorites. I tell Aidan this to his face. I've told my kids this. When you overuse the word like, you know, like all the time, like I say like when I'm looking at like this pen, and then I'm looking like at a folder, and I'm looking like at this brief, your IQ points fall in the perception of those that are listening to you. Like has a very specific use, and it can be sprinkled in, but if like it's used like every third like time, like you speak, like it's not good. It's not good. Sorry. So that's another one of my pet peeves. I got plenty. In Life as Normal is Over, Kearney shares the screen with a photograph of his acolytes that snapped of Chris Albert when he was at, and then there's a word missing. Hey, you had extra days to do this. At least fill in the blanks, boys. As the Commonwealth explained to this court on the previous go-around, episode 598, life is over now, Kearney taunts Albert, suggesting that he will never be able to go anywhere in peace because there are turtle riders everywhere who will harass him and photograph him wherever he goes. It's only going to get worse from here. Although Chris Albert didn't personally kill John O'Keefe, he raised someone who did and was helping to cover it up. He adds, Chris, I know where you guys were today. You all were in Agawam. Is that these towns, the way they pronounce them, that says to me, Agawam, it could be pronounced snail. I mean, in Massachusetts, there's not necessarily a connection between the letters and the words that you might expect, like Peabody. I got pictures of you on my cell phone. I got people sending me pictures. You guys were at some sort of Little League thing in Agawam. Anybody know about Agawam? Yeah. Nobody's helping me with Agawam. Alberts, McCabe's, all you people were there. So just you know that there will be, quote, or italics, emphasis, life as normal is over. Again, bam, take that and make that the caption for what's going to the grand jury. Anybody that just looks at that and says, yeah, that seems to be fine, is missing a scruple or two. All right. Did you take ethics? Joyce Mahar, thank you so much. I want to know how much money Chris Albert raised for the person he unalived in his hit and run. Oh, that's right. We forgot about that. Yeah. It is frightening. I'm sure most folks who have been following this know that it's not the same fundraising there used to be. The GoFundMe page, they've taken a hit because there've been so much abuse. And what's it called? Give, Send, Go, something like that. They've made a ton of money. It's like $27,000, $30,000 toward their defense. And maybe it's more now. I think they bought a billboard. I mean, they're people are contributing to them. And I think it's just, it's the wave of Karen Reed haters that are happy to just, look the other way, as Alan Jackson would say. In Albert's Should Be Afraid, I'm certainly not afraid of Brian Albert or Colin Albert or any of Prejudice to the Defendant. Kearney himself was the author of it. So he's saying, how can he complain that this is a problem when he's the one that has come up with this sentiment? But it's just so different to have the sentiment and express it as part of an overall program and to synthesize that into a headline. There are people, look at all the newspapers, the Post, the Times. There are people that are paid just to write headlines. That's it. That's all they do. Why? Because it gets people's attention, because it creates impact, because it is persuasive. So you can't take something out of context, create a headline, and then say, what's the big deal? Everybody, knows he said it at some point. No, you've got to be responsible for what you did. This is really just their way of saying, we didn't do anything bad. Really, we didn't do nothing. We did nothing to see. Lieutenant Tully's statement that he named the videos, and again, this is subject to interpretation. Did Tully really do this, or was this Kate Peter saying, here you go? We know she found the clips. Lieutenant Tully's statement that he, quote, named the videos to accurately describe their content, often using the exact relevant phrase spoke by the defendant, end quote, Tully affidavit, paragraph 9. Also, some of Tully's titles were excerpts from far more anodyne than the Kearney titles for the full episodes from which they were taken. I was embarrassed that I didn't know anodyne. It's not really all that crazy a term. But now I feel much better because I go to the dictionary, my Buchanan edition, the dictionary. Anodyne, something that soothes or relieves pain, a source of comfort. So Tully has done everybody a favor here because his excerpts are far more soothing, comforting than the Kearney titles for the full episode from which they're taken. And that's just flat bullshit because we know the titles he wrote were innocuous. They were not nearly as threatening. Otherwise, they would have kept them, right? Let's see. Oh, here's a reference to one of them. Would have toned down Kearney's drunken lardo Michael Morrissey declares war on turtle riders. I don't see any intent there. I don't see any, your life will never be the same. I don't see that. But the court need not wade into any of the defendant's contentions about titling of the excerpts because the defendant has waived the argument. Oh, Okay. Oh, that's the continuation of the footnote from above. Sorry. I'm certainly not afraid of Brian Albert or Colin Albert or any of these punks. They're afraid of me. They should be. I would be if I were them. Again, attributing what Aidan Kearney said as a bigger part of his program into the titles that were given to the grand jury. Okay, moving on. Yeah, it's a lengthy document, but I think some of these things I'm highlighting are worthwhile here. Confronting Jennifer McCabe at a lacrosse game, undersigned counsel stated that apparently the title was assigned by the Commonwealth. The video comes from a Turtle Boy Live broadcast entitled, here's the broadcast title, asking Jennifer McCabe that question. Does she know the answer? That could not be more innocuous. It's not a bad headline because it gets people to say, wonder what that's about, which is the goal behind doing these headlines. And so somebody tunes in to see. That's not what they were spitting out to the grand jury. Catherine Peters' involvement as an informant in the investigation of Kearney's alleged crimes provides no substantial basis for reconsideration. Again, that's what they're calling this, motion to dismiss reconsideration of this court's prior denial of the defendant's motion. Okay, so why is that? The defendant claims that it learned of this for the first time on September 4. Again, we're talking now about the new information from Kate Peter and the impact on Tully and his presentation of material to the grand jury. They didn't know about it when the first motion to dismiss was filed. As fully demonstrated above, that contention is, I'm going to go with risible, like Riz. But my dictionary does not, because it's from a different country, the Buchanan edition, doesn't give me the pronouncing framework I need. But risible and or risible, I'm going with risible, is to provoke laughter. So that is a factual dispute that the court should resolve. It's risible, or is it? It's risible. I'm going with risible. If anybody wants to check me on that, you can. But I do like Riz. It is true, however, that since the previous defense motion to dismiss, the defense has acquired communication among Special Prosecutor Mello, Lieutenant Tully, and Ms. Peter, and so has new evidence. That's the one thing they've said that makes sense and perfectly legitimizes this motion, or reconsideration, if you want to call it that. Doesn't mean it'll win, but at least acknowledge, yeah, this is new stuff, and then go ahead and make your argument as to why it makes no difference. That being undisputed, the remaining legal question for this court is whether the significance of that evidence is such that substantial justice should dictate an undoing of Judge Doolin's previous denial of the motion to dismiss. It should not. Well, if you say it should not, then we're done. Why are we even here arguing? You said it should not. Again, misleading the grand jury is a problem. And if you can't see that, I understand advocating for your client. I get that. You go into it, you have a certain mindset that you have to pursue. But I think you can go over the top by being so holier than thou when clearly you're trying to justify misleading a grand jury. You're trying to say it's okay, it's fine, there's nothing to see. There is a factual dispute that the court should resolve. Oh, well, that's an interesting request. The defense paints Ms. Peters as a member of the prosecution team, indeed, the dominant player to whom Special Prosecutor Mello, quote, outsourced investigative work, end quote. The implication of the assertion apparently is that Mello and Tully were spoon-fed maliciously edited clips by Ms. Peter, which they then mindlessly regurgitated at grand jury exhibits. I couldn't agree more with that. That's exactly what happened. As Lieutenant Tully's affidavit demonstrates, that's not the case. Oh, it's not. Ms. Peter was not part of the prosecution team, but a source of information among many sources. Oh, really? Who else? Just tell us. Who else you've been talking to? Lieutenant Tully's affidavit demonstrates it's not the case because she was not part of the prosecution team, but a source. Okay. The primary source of information was the victims. That's an interesting use of grammar there. The primary source is singular, so I'll let you use was. The victims of Kearney's broadcasts who complained about them to the Commonwealth. Although, to be sure, Peter may also have brought some of that information to Mello's or Tully's attention. If you blend those together, you got Melly's. So they're acknowledging, on the one hand, that she may have had something to do with it, but they're definitely minimizing her role and saying, to some degree, it was Mello and Tully that came up with the final product. Well, so what? Again, look where it went. Look what the intent was in creating that intent. So I'm not all that concerned who did most of the dirty work. We know where it ended up, and we know the end result. Where's my footnote? Where did that go? Let me find that. Sometimes I skip over the reference to the footnote, but I know how important the footnotes are. Where are you? Yeah. Oh, there it is, buried up here. Investigative work, yeah. On the one hand, the defense is highly critical of the Commonwealth as ignorant or dismissive of Peter's woeful credibility. On the other hand, it never fails to adduce the slightest boast by Ms. Peter as to her own importance to the investigation as credible. That sounds on first blush like somebody's trying to kind of talk out of both sides of their mouth. That's not true. You can be critical of somebody's credibility and still acknowledge that she thinks she's very credible and she thinks she's very important. I don't see a conflict there. I don't.